If you have just been named an heir or personal representative in Florida, the legal system probably feels like an avalanche of deadlines and paperwork coming at you all at once. But you do not have to figure this out by trial and error. We are going to map out exactly how to open an estate, manage the funds without putting your own money at risk, and legally handle inherited property. Before you do anything else, you need 3 specific items: the original will, a certified death certificate, and a rough estimate of the estate's overall total value. Gathering these 3 documents right away puts you in a position to take immediate control of the assets and avoids the filing delays that trap a lot of families early on. Your first major decision is figuring out which legal track applies to your situation, and that depends entirely on the total value of the deceased's assets. This flowchart compares your 2 options. On the left, summary administration takes 4 to 8 weeks for estates under $75,000. If assets exceed $75,000, formal administration is required. This process typically takes 6 to 12 months. Regardless of which track you end up on, Florida law requires whoever has the original will to deposit it with the local circuit court clerk within exactly 10 days of learning of the death. Missing this 10-day window or filing your paperwork under the wrong administrative track causes immediate court delays. Getting this right on day 1 sets the foundation for everything that follows. Step 1 in the court process is filing a petition for administration. This officially opens your case with the probate division. Once the judge approves your petition, the court issues letters of administration. This document is what actually grants you the legal authority to access and manage the deceased's assets. Firmly, before you get those letters, never pay the deceased's ongoing bills out of your own personal pocket. Paying estate debts prematurely is unauthorized and can create permanent personal financial liability for you as the representative. Instead, once you have your letters of administration, immediately apply to the IRS for a unique Estate Employer Identification Number, or EIN. You will use that specific EIN to open a dedicated estate bank account, which will handle every single transaction for the remainder of the process. Under no circumstances should you mix estate funds with your own checking or savings accounts. Maintaining this strict, documented separation of every dollar is the exact mechanism that shields you from legal penalties and protects your own financial security. With the bank account open, the law requires you to publish a notice to creditors in a local newspaper and send direct service to any known creditors. This starts a strict 3-month window for unknown creditors to step forward and make claims against the estate. You cannot skip or shorten this waiting period. This pie chart shows costs, typically 3 to 7% of the estate. It includes minor court fees, sliding scale attorney fees, and a 3% personal representative fee. If you are a beneficiary, you can waive that fee to avoid an income tax hit. Knowing that you have to wait out this mandatory 3-month pause and seeing exactly how statutory fees are calculated helps you budget the estate accurately and prevents frustration when the court process feels slow. If the estate includes real estate, leaving a house vacant during these waiting periods is a major mistake. A lapsed vacancy clause can actually void the homeowner's insurance right when you need it most. To prevent that risk, you can run the real estate transaction at the exact same time as the probate case. This chart maps the dual timeline. While probate court advances on top, you can legally list the house, show buyers, and negotiate below. However, you cannot legally close the sale or transfer title until a judge issues the final letters of administration or distribution order. While you wait on that closing date, you will pay off any valid creditor debts and file the deceased's final income tax return. Once the debts and taxes are cleared, the remaining assets are distributed to the beneficiaries, and you file a petition for discharge to officially close the court case. By overlapping the sale of the house with the mandatory court waiting periods, you avoid paying months of carrying costs on an empty property, and you drastically shorten the time it takes to reach the final payout. You now have a clear sequence of actions. Deposit the will within 10 days, secure your letters of administration, protect yourself with an EIN, and fast-track any real estate sales. If you are going through a formal administration, Florida law requires the personal representative to hire a probate attorney to handle the case. Your next step is to search your local county clerk's website for specific filing checklists. From there, use the Florida Bar Lawyer Referral Service to find vetted local legal counsel. Armed with this strategic roadmap and the right attorney, you have what you need to navigate the probate system efficiently and protect your family's assets.